Sorry about that, Mr. Beard.
Could we turn to authorities bundle, tab 4, external page numbering 26?
26, did you say?
Yes.
Tab 4.
Yes. I'm just going back to section 5. So, when we were running through this in setting out the historical position in the context of this piece of statutory drafting, I highlighted, first of all, that you've got generalised functions being referred to in relation to 5.1, and therefore, when it comes to talking about the duty of Ofcom to carry out those functions, there is real sense in that verb to carry out referring to the generality of functions. Obviously, the perspective of the judge below was that one focused on the particular issue in relation to the proviso. If one thinks of the functions as being licensing functions, of course, one has no difficulty with saying that those functions are being carried out by Ofcom, whatever the nature of the direction given by the Secretary of State. Indeed, when one moves to look at the language of sub 2, it shall be the duty of Ofcom to carry out those functions.
So sorry, which page did you say we were supposed to be on?
26.
26.
Tab 4. Authority bundle.
Oh, sorry. I was at 26. Right, yes.
So if we were to read functions in a general sense as meaning here the licensing functions.
Yes, which is of course the title of the relevant section of the WTA, then you completely avoid any issue here because you don't have any interpretive tension. It's only when you then say, oh, well, actually one of the functions is a particular instruction that's effectively given to Ofcom by what is now subsection 4 of section 8, that you end up with any issue about the language to carry out. Now, just in relation to that language, to carry out those functions in accordance with such general or specific directions, so it's contemplated, detailed, and general directions. But, as I say, the verb to carry out is just an entirely appropriate verb to use when you're talking about a whole range of functions, and therefore to attach particular weight to that verb being used and say, well, you are not carrying out a sub-function in relation to licensing, in relation to the proviso, and therefore contradicting the language, we say is going too far. Indeed, it is perhaps notable that in the explanatory notes in relation to this section, there isn't even reference to the term carry out. Now,
is it notable? I mean, explanatory notes, they don't use the same language, otherwise it'd be pointless.
Well, that's undoubtedly true, but if it was so critical,
I don't think it's critical at all. It's just where it's been worded.
Well, in order for it to carry the weight which the term carries in the court below's exposition and explanation of this section, one might have expected it to have had more significance. In the context of what I have raised already, a very broadly drawn power in 3, albeit confined to those very important and limited interests, and then also reinforced by the fact that the operation of that power is further specifically confined by subsection 4. We say, therefore, you should not read the phrase to carry out those functions in accordance with as delimiting the scope of the directions that might be given. And that was essentially the way in which the judge below approached it.
It is delimiting, isn't it? I mean, it's exactly what it's doing.
Sorry?
It is delimiting.
Well, we say it's not delimiting.
Delimiting is just another word for defining.
Or constraining the scope of. And we say in circumstances where the draftsmen have put in place broad powers, albeit on narrow interests, and specifically confined them in 4, one shouldn't be reading 2 as further confining, as your lordship puts it, the scope of those directions. So we say the language of to carry out and in accordance with means that you must do, consistent with the Secretary of State's competence in this overall scheme, what the Secretary of State requires in relation to licensing or exemption by way of direction. The third point I want to make is that this language of to carry out, as I picked up on the way through, is used in other sections. If one turns a page back to page 24, you see it in section 4.2. It shall be the duty of Ofcom in carrying out any of those functions to act in accordance with the 6 community requirements. Now, obviously subject to what is about to happen at the end of December, community law would be supreme in relation to any obligation. Therefore, it is possible that requirements under community law would conflict with the operation of functions under the provisions that are being referred to in 4.1. In those circumstances, there would be no doubt that Ofcom could not undertake particular functions referred to in 4.1 if they conflicted with the operation of those 6 community requirements. That would mean that it was not, to use the language my Lord Justice Flaux highlighted earlier, was used by the respondent. It would be not carrying out those functions in accordance with community law and the community requirements. But plainly, that would be consistent with the language of 2, because subsection 2 is contemplating such an outcome. In other words, that the carrying out of those functions includes the not carrying out of those functions. Now, there is no proper answer to
Is that so when we mustn't overlook the fact this is a duty we're concerned with here?
Yeah.
Are you saying the same would apply
Well,
if the duty under 8.4 applied,
yeah.
but carrying out that duty or performing that duty, in other words, making an exemption
Yeah.
contradicted any of the community requirements?
Yeah.
You're saying this would trump it?
Yeah. Obviously must do. And it's not just in
Well,
relation
that
to
would be, well, no, according to the statute, as a matter of ordinary statutory construction, I'm not sure it would. Clearly, it would as a matter of community law.
Yes, it would as a matter of community law, but the draftsman of this in 2003 will have known that a community requirement can trump, and I don't just mean this duty, but any particular function that is listed in 4.1. And yet the language used by the draftsman here is carrying out in accordance with. And there is no, and therefore it reinforces the fact that one is over-reading carrying out in accordance with if one adopts the approach of the judge. The only answer that is given by the judge and the respondents, as I understand it in relation to this, is to turn back to
So if it were a community requirement of community law, that you should only grant an exemption in certain circumstances.
I'm so sorry, my lord.
If it were a requirement of community law not to grant exemptions,
Yeah.
then you say that would trump anything in section.
In relation to the functions dealt with in 4.1, I mean, I'm being necessarily cautious for 2 reasons. One is because the exemptions process is driven by community law, so I'm not saying that there would necessarily be a clash in this case.
No.
And the second thing is that the functions that are referred to in 4.1 do not, in fact, include the functions in relation to spectrum use, because that's Chapter 2 of Part 2. And so I'm making this point as a matter of generality. I answered my lordship's question on a hypothetical basis. The point I'm making is about the statutory construction here.
Well, you're essentially making the point that in other provisions, carrying out isn't limited to actual carrying out. It can include not carrying out.
Yeah, and therefore that's perfectly consistent. That's the point. And the only answer that's given is a reference back to.
Sorry, you said earlier that duties in section 4 don't include the ones with which we're concerned here.
In 4.1, yes.
What, I'm sure you're right. I just hadn't picked that up. I thought I'd rather assume they were under 4.1b.
I'm sorry, they are under 4.1b. I was misspeaking. Certain of the provisions, you are right. They will be under 4.1b. They won't. All of the spectrum governing functions are not covered by this because they're under Chapter 2. But these are. You are correct, my lord. I correct myself. I'm sorry.
So does that support your?
Yeah, it does actually support, because when I'm not answering it hypothetically, but really, it does support my case. So I apologise. Your lordship.
But they don't include Chapter 2 of Part 2.
That's it.
Which is actually where the licensing and exemption.
Exactly. That was where I was getting confused, and I apologise. But my lordship is absolutely right in relation to B. I'm so sorry. But as I say, can I just deal very briefly with the putative answer that the court gives to that point? Because we say that that's a compelling point, because obviously in relation to European law matters, it would be bizarre if a draftsman were contemplating that somehow there was an implied constraint in the statutory drafting as to how you could apply supreme community law. And that is, one needs to go back to section 3.6, which is on page 23.
Yeah.
And just for your notes, this is the reasoning that the court gives at paragraph 59 of its judgment, rejecting the submission I've just made in relation to 4.2. It says, in any event, unlike the position with 5.2, 3.6 of the Communications Act makes express provision for any consequential conflict between a 4.2 duty and other duties of Ofcom. And with respect, that's just wrong. Because if one looks at 3.6, what it says is where it appears to Ofcom in relation to the carrying out of any of their functions mentioned in 4.1, so it's cross-referring to the functions in 4.1, that any of their general duties, so that's the duties in section 3, conflict with one or more of their duties under section 4, priority must be given to their duties under those sections. So when you're carrying out your section 4.1 functions, if there's any conflict between general duties in doing them and, in particular, community requirements.
And so far as section 4 is concerned, it's a very convoluted way of saying that the duty to comply with community obligations overrides anything else.
Yeah, it is. But the reason it matters...
Which would have been a much easier way of saying the same thing.
I'm not actually going to disagree with you, my lord. The point I make is that they used that language again.
Yep.
And it's essentially a fortiori the position in relation to section 5, because you cannot suppose that a draftsman was sitting there thinking, oh yeah, actually, even if community requirements trump any of these functions, including duties, but any functions, it doesn't matter because we can ignore that trumping effect because that would mean we're not carrying out those functions in accordance with community law. And therefore you end up with a clash between the domestic statutory regime and European law. And so we use that as an exemplar. And there is no proper answer to that. And 3.6 is not it. So we say that you've ended up with a situation where you're putting too much weight on the verb to carry out. You have other usages here which illustrate the point. And then the fourth point I want to make just in relation to language is one that I made before the short adjournment, which is that at paragraph 57 of his judgment, the judge refers to the term in accordance with, meaning in line with or in the same direction as. And we say that just doesn't make sense. We don't understand what that phraseology means. It's a gloss on language that is unhelpful. If you're going to put any translation of that wording, it should be subject to. That is obviously the more natural way of reading it. And again, the in accordance with language, even if you're not glossing it, simply fits with the broad power on a narrow range of subjects that is conferred in 3 and says you must act in accordance with those. And so
all that means is you must do what they say.
yes, you must do what they say, but that's it.
Yeah.
Yeah,
It's
I
a-
don't quite see why anyone attaches importance to this either way.
If it had said that it shall be the duty of Ofcom to act in accordance with the general and specific direction, it's perfectly obvious, isn't it? They've got to do what
Yeah.
the Secretary of State tells them to do.
And we say that
So the debate is about carry out and not really about...
yeah, and we say we're just freighting too much. The judge was trying to freight that one verb with too much meaning in these circumstances.
Well, to be fair, I think he was meeting a point that you'd apparently made. I do not accept that they're synonymous with subject to,
Well, yeah.
which I slightly agree with him. Subject to also is a gloss.
Well,
I got no problem in accordance with meaning in accordance with.
Yeah, well,
Following.
we don't have a problem with that. It was during the course of submissions.
Yes,
we were
I see.
saying actually
That's in accordance with.
it means in accordance with, but what it doesn't mean is that there's some kind of constraint implied constraint from that phraseology into the scope of the direction of giving power, which is what the judge was finding. So hence the fight. Yes, it probably was triggered by us, but that was where that's where we ended up. But we say, do follow in accordance with. That is important. Don't put so much weight on carrying out. When you compare it with 4.2, you've got good reason for saying that actually the fundamental principles that I've articulated, the role of the Secretary of State, the importance of national security and so on, make that provision tolerably clear. Now I'm going to very briefly deal with case law that the judge relied on, saying that actually these provisions should be read at the starting point that was that you should have particularly clear language. Now, with respect to the judge, he set this out in paragraph 50 of his judgment. That is the wrong starting point.
Paragraph which of his judgment?
Paragraph 50.
Yeah.
He talks about the principles of statutory interpretation. Principles 1 to 3 about validity or otherwise of subordinate legislation. We don't take issue with the principles. Quite how they fit in the context of this scheme, where you're talking about a primary legislative duty being imposed on Ofcom to act in accordance with the directions of the Secretary of State, and why one then is talking about this in the same way as secondary legislation is not entirely clear, but leave that to one side. We move to subparagraph 4, where he places weight on the doctrine articulated in Unison and JCWI that specific statutory rights are not to be cut down by subordinate legislation passed under the vires of a different act. Completely irrelevant with respect to
This isn't a Henry VIII situation at all.
well,
Two pieces of primary legislation.
I probably don't need to
Power
go
is a
further.
power.
I think I would use your limited time differently than
That's
on this
fine.
point.
We're there. I'm moving on.
I can cross that out then.
Well,
You're saying that it
we
didn't.
say yes, you can cross that out, and yes, you can cross out the references to Henry VIII powers, and yes, you can cross out the references to abrogation of fundamental rights principles, not because they're wrong, but because they're inapplicable here.
Because this is two sets of primary legislation.
Exactly. Sorry, I was being too brief, my lady. But yes, that is absolutely our position, and none of that case law takes anyone anywhere further forward. That does mean that I have to. There is one authority I should touch on in slightly more detail, which is the EE authority, Authorities Bundle, tab 21, if I may. Now, the judge saw this authority as being supportive of his interpretation. The respondents say the same, and they say it's somehow the converse of the current situation and terribly illustrative. I'll just outline what was going on in EE. In EE, what had happened was that pursuant to EU obligations under that common regulatory framework, Ofcom, as the national regulator, had been charged with the power and duty to set licence fees in relation to spectrum auctions and telecommunications services and various things. That obligation had actually been embodied in Section 12 of the Wireless Telegraphy Act 2006. It's not in the bundles, but it doesn't matter. The Secretary of State, however, relied on powers in Section 5 of the Wireless Telegraphy Act, effectively to make an order specifying how licence fees should be set. And so this was a sort of attempt to repatriate to the Secretary of State the licence fee setting power. And what the court considered was whether or not that was contrary to EU law obligations and whether or not directions could be made under Section 5 of the WTA 2006. And if we turn to paragraphs 53 and 54, 53 says Section 5 of the Wireless Telegraphy Act 2006 allows the Secretary of State to give directions to Ofcom about the carrying out by them of their radio spectrum functions. This is a provision we've seen, and I'll take you back to briefly. And it works its way through. Final sentence of that paragraph, it's phrased in terms of requiring Ofcom to exercise its powers so as to implement the package of reforms, including directing Ofcom to raise the licence fees. And then 54, the question therefore arises whether Section 5 of the Wireless Telegraphy Act authorises the Secretary of State to direct Ofcom in exercising its Section 12 powers to ignore the duties imposed on it by Section 4.2 of the Communications Act. Now, we've just been looking at 4.2, that's the community obligations provision. And it says, in my view, it doesn't. Parliament's imposed those duties on Ofcom, compatibly with the Framework Directive, to be performed in carrying out its radio spectrum functions. It didn't obviously contemplate, or in my view, authorise the performance of an Article 8 duty by someone other than the regulator. In the absence of clear words, the Section 2 duty is to be treated as non-delegable. And there's nothing in Section 5 which in terms allows the Secretary of State to relieve Ofcom of the statutory duties which Parliament has expressly imposed on it. Now, obviously, the claimants, and indeed the court below, fixed on this language of relieving Ofcom of statutory duties and said, well, this is fine authority. But if we actually turn back to the relevant provisions, we've seen 4.2, and what 4.2 says is you must comply, you must carry out functions in accordance with EU law. So what the court was asking itself was there another power that effectively allowed you as a Secretary of State to abrogate obligations under EU law? And unsurprisingly, what the court says is no, there isn't. And it's worth just turning up again Section 5 of the Wireless Telegraphy Act 2006, which we have at tab 6 in this bundle. And I've already taken you to before, and you'll recall that this was effectively a transposition of Section 156 of the Communications Act. This is page 7 in tab 6. Section 5, the Secretary of State may by order give general or specific directions to Ofcom about the carrying out by them of their radio spectrum function. So about the carrying out by them. There's no in accordance with here, worth noting. And as we've already noted, this is much more parallel to the Section 132 structure in giving directions by the Secretary of State rather than the 5.3.
The reason why there's no in accordance language is that there is nothing telling Ofcom, obliging Ofcom to comply with such directions. Presumably that's implicit.
I think it would have to be, yes, from subsection 1.
Yeah, so it's a rather different drafting structure.
Yes, and as I say, it's very different from 5.3. And indeed, you'll recall that I pointed out that this structure has at the end a tailpiece that says this section doesn't restrict the Secretary of State's power under Section 5 of the Communications Act.
I'm sorry, I've kind of, I think my brain's jumped into two directions.
Yes.
It does say in accordance with.
I'm sorry.
subsection, on page 7, the Wireless Telegraphy Act, section 5, subsection 3, after D, as may be specified in or determined by the Secretary of State in accordance with.
I'm sorry, yes, you're right. I was just referring to sub 1, which is just that there isn't the same connection of carrying out in accordance with.
I see.
Well, it's a requirement to exercise their powers in accordance with.
Yes. Sorry, your ladyship.
No, I want to follow the argument, which is why I thought.
Yeah, I'm not going to emphasise that. It is separated out, but I emphasise the use of in accordance with in the context of the other provisions. But the key point I want to highlight here is that this power is very different from the structure of 5.3 and indeed is specifically delineated from 5.3 because it is made clear that the 5.3 power continues to exist and is different from that.
But your broad point about EE is that it was addressing a different issue with arising out of different statutory provisions.
Yes, different wording, different structure, different considerations of the issue. It's not with authority. So in the last couple of minutes, if I may, I won't take you back through the other judgments that the court below traverses. It's worth noting that in the judgment below, at paragraph 69 to 70, there is the quotation of and consideration of the judgment of Mrs. Justice Rose, who, in reaching her conclusion, considered that the Secretary of State would have power under Section 5 to make a direction to require licensing, but decided that that wasn't necessary in the circumstances because there was a pre-existing commercial use restriction and that had not been impliedly or explicitly withdrawn under the Communications Act, and so it didn't matter.
But, I mean, recall doesn't really help us either way, does it? Because what Mrs. Justice Rose said isn't binding on us and is very briefly reasoned. Lord Justice Richards obviously thought there were real problems, but deliberately didn't decide.
Yes.
So we're just having to confront the questions.
Yes,
that he
absolutely.
did. So I think recall's a bit. You've been quite right, if I may say so, not to rub our noses in recall. It doesn't help anyone really.
No, as I say, and just to pick up, Lord Justice Richards refers to some other statutory provisions, for instance, Section 94 of the Telecommunications Act. I should stress, though it's in your bundles at tab 7, that's no longer in force. It's been overtaken by the Investigatory Powers Act. That was different language, different circumstances, a separate act.
You made that point going through, I think.
Yeah.
And the other one that he refers to is Section 3.5 of the Wireless Telegraphy Act. I've already touched on that. It's a very different beast. If Mr. Segan's going to make anything of that, then we'll deal with it in due course. The final couple of matters, if I may, you asked about references to the consideration of proportionality by Lady Justice Rose.
Although I read her judgment over lunch. It really doesn't help us, does it?
Well, it doesn't help in the sense that it isn't considering the hypothetical set of conditions that was being canvassed before lunch, because what had been put forward by the claimants in that case are set out as conditions in paragraph 23 of her confidential annex, and they were very, very different sorts of conditions. She did then carry out a proportionality exercise and say those sorts of conditions would not be sufficient to meet the national security concerns, and therefore.
Well, you better tell which paragraph. We won't read them now with you. But just
23.
Well, that's setting out. So, which are the ones where she says those wouldn't do the trick?
36. But there's a discussion from 28 and then 36.
Oh, but that's about a different point. It's about the availability of technical means.
It's not. with respect, because the conditions that were put forward related to actually having other people provide inputs into the operators of GSM gateways, such that the relevant information pertaining to CLI could be provided. That's why I pointed you in the direction of paragraph 23. And so that is why there is a discussion of technical means and why the conclusion is reached.
Yes.
I'm sorry, I've dealt with that in a rather abbreviated form. I'm concerned. She made a finding on proportionality. It was in relation to a different set of proposed conditions than the ones that you were putting forward. The point I was making earlier was that insofar as there'd been any consideration of what conditions might work and how they might work, there had been a specific finding that they wouldn't fulfil the conditions of proportionality.
But if they're not the same conditions, I don't quite see how it helps you, but I'm afraid you're running out of time.
Yes. I just wanted to pick that up. And then finally, in relation to the judgment, I think it is worth mentioning that in relation to the set of alternative conditions that were being canvassed before the short adjournment, if it were to be the case that those sets of conditions in relation to conditioning an exemption rather than conditioning a license would have the same protective effect of national security, the reasoning of the court below in relation to paragraphs 86 to 88 would not be correct in relation to the operation of the section 31(2)A of the Senior Courts Act, because what the court was canvassing, I think, before the short adjournment was a set of conditions that would not result in a different outcome, at which point questions as to relief would arise under.
Okay, well, we'll deal with that when if we get to it.
But I just note that in the light of the.
Okay.
Unless I can assist the court further, I'm grateful.
Thank you very much, Mr. Beard. Yes, Mr. Segan.
My lords, my lady, it's worth emphasising at the outset that the only issue in this appeal is a pure point of law, a question of vires as to whether the Secretary of State has power under Section 5 of the 2003 Act to direct Ofcom not to comply with its duty under Section 8, subsection 4 of the 2006 Act. There is no issue in this appeal about whether the Home Secretary is the right person to make national security judgments, whether her predecessor made the right judgment about COMOGs or anything of that nature. My client accepts and has always accepted that substantive policy judgments of that nature are a matter for the government acting within the law. And those last four words are important because, of course, what the law insists upon in return is that whatever action the Secretary of State takes is within the four corners of the powers conferred by Parliament. And in this case, we say the High Court was absolutely right to find that the four corners had been exceeded. And the issue which arises in this case is unavoidably stark. There has understandably been some discussion in argument as to other directions that could hypothetically have been made. But the direction with which we are concerned in this case was in terms squarely contrary to the duty in Section 8, subsection 4. Indeed, the judge recorded, paragraph 32 of his judgment, that it was common ground that the direction by its terms instructed Ofcom not to comply with its statutory duty under Section 8, subsection 4 of the Wireless Telegraphy Act 2006, and that is, in my submission, what the first sentence of the direction.
What paragraph says of the judgment?
Paragraph 32. And that is, in my submission, what the first sentence of the direction inescapably seeks to do. And we submit, quite simply, that the Secretary of State does not have the power to give such an instruction, and that the High Court was right so to hold. In a nutshell, if a member of the executive is to have the power to override what would otherwise be the effect, the mandatory effect of a piece of primary legislation, then that power has to be conferred in clear words. General words do not suffice. And that is a principle of considerable importance, which the courts have been very careful to safeguard over many years and in many cases in many different areas of the law. And when one applies those very well established principles to Section 5 of the Communications Act 2003, we say, as I shall be developing, that the answer is clear and was correctly given by the High Court. The direction exceeded the Secretary of State's powers. Section 5 gives the Secretary of State the power to direct Ofcom as to how to carry out certain of its functions. And as I shall be showing you, it's a very long list of functions when you look at the whole list to which Section 5 actually on its face applies. It does not confer, certainly not in clear and specific words as the law requires, a power to direct Ofcom not to carry out statutory duties. And that submission is then supported by a series of contextual factors which I shall develop. Now, of course, how the Secretary of State responds to that is and properly a matter of the Secretary of State. But the question for the court in this appeal is the pure question of law, no more and no less. And on that question, we say the High Court was right. Now, in developing that, I want to take my submissions effectively in three chunks. Firstly, some very brief points on the factual and legal background. I can go very quickly there because my learned friend has covered pretty much all of it. I would like to develop the 5 principal points that I've set out in paragraphs 27 to 52 of my skeleton argument and pick up my learned friend's principal points along the way. And then finally, respond to the 5 grounds of appeal as elaborated in my learned friend's submissions just now. So, dealing firstly with the factual and the legal background, my learned friend has already shown you the Wireless Telegraphy Act 1949, the 1999 exemption regulations, the 2003 exemption regulations. I don't need to take you back to those. My learned friend did mention the Common Regulatory Framework. And that is, it's important that the court should see that because that is the background, of course, to the Communications Act 2003 and to the framework that was set up. And you have the directive, the relevant directive for present purposes in tab 3, the authorisation directive. I just wanted to show you very quickly a series of provisions which make clear what this framework was all about. You can see in recital 1, about 8 lines down, after having referred to previous experience, it had confirmed the need for a more harmonised and less onerous market access regulation for networks and services throughout the community. Recital 7, the least onerous authorisation system possible should be used to allow the provision of electronic communications networks and services in order to stimulate development, etc. Recital 8, those aims can be best achieved by general authorisation of all electronic communications networks and services without requiring any explicit decision or administrative act by the National Regulatory Authority and by limiting any procedural requirements to notification only. So when you're looking at what the overall purpose of this scheme actually was, it was explicitly concerned with the abolition of individual licensing arrangements. Then recital 15 over the page says that any conditions attached to the general authorisation should be limited to what is strictly necessary to ensure compliance with community law and the such like. Then in Article 2 on page 25, you can see general authorisation is defined in subparagraph 2, and I shan't read it out, it's essentially an exemption on conditions. Article 3, subparagraph 2, the provision of networks or services may, without prejudice to the specific obligations referred to in Article 6 or rights of use in Article 5, only be subject to a general authorisation. The undertaking concerned may be required to submit a notification, but may not be required to obtain an explicit decision or any other administrative act by the national regulatory authority before exercising the rights stemming from the authorisation. And then specifically in relation to radio frequencies, Article 5, Member States shall, this is page 26, where possible, in particular where the risk of harmful interference is negligible, not make the use of radio frequencies subject to the grant of individual rights of use, but should include the conditions for usage of such radio frequencies in the general authorisation. Now, the primary means by which that was then implemented in domestic law was the Communications Act 2003. And we have the explanatory notes at tab 26. The reason I want to take you to them, I just showed you Article 5 of that directive about the abolition of individual licensing. That is the article to which the duty under Section 1AA was seeking to implement. So you can see in the explanatory notes,
Where do we find those?
tab 26 of the authorities bundle, page 8 of it. Sorry, that's not page 8, that's the Section 5 one. We need to go forward to the note for Section 166, which is at the very end.
Internal page.
It's internal page 9, but I suspect there's more than one
You go to the
9.
very last page and it's
Yeah.
the one before.
Section 166, exemption from need for a wireless telegraphy licence. This section amends the Wireless Telegraphy Act 1949 to require Ofcom, etc., and then the summary. This implements Article 5.1 of the authorisation. So that's why the Section 1AA duty was actually introduced. We know that it was Section 166 of the 2003 Act that did that. One can find that in tab 4 in the 2003 Act as enacted, internal, or using the bottom pagination, page 150. That's section 166. That's the section that inserted section 1AA. Now, in my submission, just looking at that provision, there was no indication that that statutory duty enacted by and inserted into primary legislation was to be capable of being overridden by an executive direction under section 5. On the contrary, where the draftsman of this Act intended duties to be subject to directions under section 5, he or she said so. And one can see that 8 pages earlier in the clip, page 142, we've already seen it, section 154, duties of Ofcom when carrying out spectrum functions. Subsection 4, where it appears to Ofcom that any of their duties under this section conflict with any one or more of the duties under sections 3 to 6, priority must be given to their duties under those sections. So where the draftsman intends section 5 to be capable of overriding, he or she says so explicitly. I shall obviously, of course, come back to the wording of section 5 in due course, but the next step in the relevant history, of course, is the Wireless Telegraphy Act 2006, Authorities Tab 6. And as we've seen in section 8,
Remind me why that was necessary, the 2006 Act? Was it just a tidying up Act?
it was a consolidation of a whole series. We'll actually be seeing in due course a list of which acts it consolidated. But it was a consolidation of lots of bits of wireless telegraphy legislation. Section 8, of course, as we know, reenacts the Section 1AA duty. Now, at this point, Parliament is reenacting the duty. It would have been perfectly straightforward for Parliament to have enacted the Section 8, subsection 4 duty as being one subject to a direction from the Secretary of State under Section 5. But Parliament did not do so. And to the contrary, in the very same Act, again, in Section 3, Parliament makes provision for certain duties under the 2006 Act to be capable of being overridden by a direction under Section 5, but not the duty in Section 8.
Sorry, where are you now
So
referring to?
this is Section 3, subsection 5.
Where did we find that?
At page 5 of the clip.
Hang on, which?
In tab 6. My apologies.
Page 5.
Tab 6, page 5.
Where are we looking at?
Subsection 5.
So that's
tab
the same
6,
as.
page 5.
So this is the same as section
154. Exactly. But the point I make, obviously, is this is Parliament considering again the question of the duty under Section 8, reenacting the scheme, not providing that Section 8 is subject to a direction under the 2003 Act. But not just that, the issue was actually considered as to which duties in this Act should be capable of being overridden. And Section 8 is not one of them.
Where do you say it's, I mean, slow? It's not one of the sections 3 to 6, yes, I see.
Exactly.
But the Communications Act that we've been looking at, doesn't Section 5 contain the duty that Ofcom should act in accordance with the directions, general or specific, of the Secretary of State, albeit within those restricted elements? And here we have a subsection 5 saying that if the duties of Ofcom appear to conflict with one of those duties, then those duties trump.
Correct. But only in respect of a duty under this section, Section 3 of the 2006 Act. And this is actually the same Act as contains the Section 8 duty.
So hang on a moment, just the duties under Section 3, which go back to the duties under Section 154 of the Communications Act, do not include licensing and exemption, is that right?
They do not include the duty under Section 8.
No. And that's your point. That if it had been intended that Section 8 was subject to the same limitation, it would have been very easy to insert.
Would it be incredibly easy to say so? You just say it in Section 8.
And just get one point out of the way, perhaps we're coming back to this, but if it had done that, that wouldn't have been contrary to community law.
No,
Because community law does allow licensing, in effect, where to the extent necessary for national security.
That's right, my lord.
So in a sense, all your intro, I show you why you've given it to us, about the directive, is only neutral from your point of view, isn't it?
Yes, I wanted you to see why the scheme was put in place, but my point is a purely domestic one. I accept that it would have been open to the UK to make that provision, but that's not what Parliament did.
But isn't Section 3(1), which refers to the spectrums, imported into Section 8?
No. It is, well, you can see the duties under Section 3 are those set out in subsections 1, 2, 3 and 4. And those are the duties being referred to, subsection 5.
But it says, in carrying out their radio spectrum functions, Ofcom must have regard in particular to, not exclusively, but
Yeah.
in particular to.
Yeah.
Section 8 refer to radio spectrum functions.
Section 3 is imposing duties to have regard, you can see subsection 1, to have regard to a series of different things. Subsection 2, to have regard to a series of different things. Those are the duties being referred to in subsection 5.
These are not, yes, these are all have regard duties.
Yes.
They're not do something duties.
No. It's saying where it appears to Ofcom that a duty under this section conflicts with one or more of their duties.
It's not saying where it goes to Ofcom that the carrying out of its functions conflicts.
No. That's right.
That's the point, isn't it?
Yes, exactly.
Section 8 is about carrying out functions. Section 3 is about the duties you owe in carrying out the functions.
Yes, quite. Your Lordship has put it much better than I have, but yes, that's the point. Now, as we know, there was then the expansion of the permissible grounds of exemption in Article 5, changes which came with the Better Regulation Directive. My learned friend has taken you through that. The expansion of the list in Section 8 by delegated legislation. The recall proceedings then in which co-sub use was held, the commercial use restriction in respect of co-sub use was held to be contrary to EU law, and therefore there was the liberalisation, and then the question arose of co-mug use. And Ofcom obviously had its consultation. I don't know if you've been taken to it yet. I don't think you have. It's a supplemental bundle, tab 8. I'll just quickly show you some parts of this. First of all, 1.8, there's reference to the congestion effects and to the fact that MNOs are best placed to manage. It's the same approach adopted in other European countries like the Netherlands, Ireland and Germany, who have no legal restrictions on the use of co-mugs. Then the CLI point was raised, 1.9, and obviously it was addressed through the prism of the endangerment of safety of life question, because that's the formulation used in Section 8, subsection 5.
Sorry, I'm just being slow. This is the notice of the proposed regs post-consultation.
Yes, it is.
So it incorporates a report on what the consultation is.
Yes, exactly.
Yeah.
Exactly. And you can see, I'm not suggesting for a moment that this included a full national security assessment or anything of that nature, but what there was is consideration of submissions by the Home Office in the context of endangerment to safety of life in 3.51 onwards at page 174.
So was the Home Office a consultee?
Yes. Well, it responded to the consultation, and I should imagine it was sent to the Home Office. I would expect that.
Yeah,
and
I
you
can
can
confirm it was.
Yes. And so there's a reference to the Home Office's concerns, etc. And at 3.58, Ofcom says the Home Office does not explain how or why co-mugs presented this is any greater or more direct than other lawful means of communication. We know, for example, the marshalling call location line.
Sorry, where are you reading from?
3.5,
I haven't read
page 100.
this before, but this is all about endangerment to safety of life,
Yes.
which is one of the Ofcom things to which they have to
It
have
is.
regard. But it's quite clear that the consultation was proceeded with on the basis, is this right, that although there might, as Mr. Beard said, be some practical overlap with national security concerns, it's a completely different focus So they weren't consulting about national security at all. It looked as though the Home Office sort of understood that.
Well, the footnote 34,
Yes,
makes
makes
clear that it's
Yep.
we're not empowered to
Yes.
take national security considerations into account.
So they follow through.
Yes, I'm sorry. I'm grateful to my lady. That makes it explicit.
And if you look at the questions that were posed in the consultation, they were concerned in this. Do you have any evidence that the installation or use of commands is likely to involve undue influence, etc., endanger safety of life?
Exactly.
Yeah.
They're all
Not
statutory
include.
questions. They run through them. They find that they're satisfied of all statutory criteria, so the duty arises.
Well, the point that I was making, which I accept is perhaps only a debating point, but having occurred to me, I better just track it down. It doesn't look as though the Home Office was saying, we look at 352, this will be contrary to national security. It was respecting the terms of the consultation, and obviously thought it could deal with national security in some other way if it chose to, which of course it's now tried to do.
Yes. But the only point I'm seeking to get is that Ofcom went through the criteria in subsection 8,
Yeah.
5. They were satisfied in relation to each of them, and therefore the duty under section 8.4 arose. And they then proposed, they in fact appended to this the regulations that they proposed, which you can see at Annex 2, page 181. I don't place any particular reliance on them, but just so you know that they are there. So the duty has arisen, and at that point, the direction is served. That's core bundle tab 15, page 217.
We looked at that already.
And you've already looked at it. The first sentence is squarely contrary to the 8.4 duty. So the question arises, does section 5 confer a power to overrule section 8.4? And we say, as I've already submitted, on very well established principles of statutory interpretation, it doesn't. That brings me to the second principal chunk of my submissions, which is developing the points in my skeleton argument. And in that regard, first point is, we say clear words are required to confer a power on the member of the executive to override primary legislation, and there aren't such clear words here.
That's not a Henry VIII point, if I put it that way.
It's not a Henry VIII point, but
It's
it
a point
is
about the nature of the power. The power is the existence of the power is conferred by the statute, but
Yes.
the scope of the power is affected really by the point you're making.
Yes, my lord. It's not a Henry VIII situation because it's not concerned with a power to amend another piece of primary legislation. That is technically a Henry VIII situation. But I should be submitting that it engages precisely the same
It's the same underlying principle.
The question is, as a matter of interpretation of section 5, was it intended to enable other statutory provisions to be overridden? Yes, not amended, but in substance the effect is the same, and indeed, particularly here, where the duty is one to make an adjustment to the general law. Because the duty under section 8.4 is to make regulations adjusting the general law. So it is, in terms of the underlying principle, a very similar sort of situation. Now, direction is a form of subordinate or delegated legislation. I've put a bit of Benyon in on that at tab 25. You can see page 1 under the heading Types of Delegated Legislation. Tab 25 of the Authorities bundle. At 7, the authors have other terms used include, and then a whole load of
Does this really matter?
different terms.
It's just
than
a
in
question of
this
how you label it. We see what it is.
Yes, that's right. That's right. Now, I've cited a number of cases on the general approach. I'm not going to take you to all of them, but I shall take you to a limited number. Probably the most important is Public Law Project. That's Authorities tab 18. This is the case about Henry VIII powers. This is a case where there was an attempt to introduce by statutory instrument a residence test for legal aid, and Lord Neuberger gave a single judgment for all 7 justices of the Supreme Court. And I would like to pick up the analysis at page 1556.
Sorry, could you give me the tab number again? Did you
Of
say
course.
18?
I'm sorry, my lady. It is tab 18, yes.
And the case?
It is Public Law Project
Yes.
against the Lord Chancellor.
Yes.
And in Lord Neuberger's judgment for the Supreme Court, paragraph 21, page 1556. Paragraph 21, subordinate legislation consists of legislation made by members of the executive, almost always pursuant to an authority given by Parliament in primary legislation. So that's engaged by the direction. 22 is establishing that the lawfulness of statutory instruments can be challenged in court, which I know won't be in dispute, and that's what is occurring in this case. Paragraph 23, subordinate legislation will be held by a court to be invalid if it has an effect or is made for a contrary, that is, outside the scope of the statutory power pursuant to which it was purportedly made. In declaring subordinate legislation to be invalid in such a case, the court is upholding the supremacy of Parliament over the executive. That is because the court is preventing a member of the executive from making an order outside the scope of the power.
I'm really sorry, but did you say this is paragraph 23?
Yes, my lady. Of Lord Neuberger.
Confusing thing is that it's got the Court of Appeal judgment immediately prior to it, and all the judgments are so short for thinking you're dealing with one.
I'm
you're
most-
dealing with
Well,
two.
you did say 1541, which I think is
I'm
page 1541, didn't you?
No, 1556, my
Ah,
lady. And
right.
apologies.
No, it's my fault, obviously. Thank you.
At 24, Lord Neuberger says, normally, statutory provisions which provide for subordinate legislation are concerned with subsidiary issues such as procedural rules, etc. However, such statutory provisions sometimes permit more substantive issues to be covered by subordinate legislation. At 25, there is then a description of a
So
Henry
just
VIII.
pausing there, you say this analysis applies here because the statute simply refers to the Secretary of State having power, but the actual direction that's given is given pursuant to what's in effect subsidiary or subordinate legislation.
Exactly. The question ultimately is about the construction of an enabling power. It's does it enable the direction that was made or not? So it is, in principle, it's the same issue as arises in respect of an alleged Henry VIII power. It's did Parliament confer a power to overrule, amend, override, whatever the case may be, other pieces of primary legislation?
Out of curiosity, and only if you can answer in a single couple of sentences, 2 sentences I'll allow you, why is it called a Henry VIII power? Is there some specific thing that Henry VIII did, or is it just he's an example of a tyrant?
I think it may relate to the Statute of Proclamation.
Yes.
Which was in effect a power for Henry VIII to rule by proclamation.
Okay, that's a very good answer.
Yeah,
And
it's a statute of proclamations which preceded either preceded or it was after the Pilgrimage of Grace.
Well, now your lordship is ahead of me on the history, and I may find out that my history is completely wrong.
I've started this hair, so I shall now put it back in its
Yes.
well, where a hair is kept. Yeah. Thank you.
But the point was, it was bypassing Parliament.
Yeah.
statute of proclamations, and that's the reason why it comes into play. And 25, line 4, when a court is considering the validity of a statutory instrument made under Henry VIII power, its role in upholding parliamentary supremacy is particularly striking, as the statutory instrument will be purporting to vary primary legislation passed into law by Parliament. I pause there. That is exactly what the direction purports to do in this case. To vary primary legislation passed into law by Parliament. It seeks to take what would otherwise be the duty under subsection 4 of section 8 of the 2000 verses. The interpretation of the statutory provision conferring a power to make secondary legislation is, of course, to be effected in accordance with normal principles of statutory construction. However, in the case of an amendment that's permitted under Henry VIII power, and then there is a reference to Craig's and approving reference, and this is important. In the 4th line of the quotation, we have, although Henry VIII powers are often cast in very wide terms, the more general the words used by Parliament to delegate a power, the more likely it is that an exercise within the literal meaning of the words will nevertheless be outside the legislative contemplation. And then we have reference to a number of other cases, and Lord Newberger picks up Lord Donaldson in McKiernan, and again in the last 5 lines of that quotation, a delegation to the executive of power to modify primary legislation must be an exceptional course, and that if there is any doubt about the scope of the power conferred upon the executive or upon whether it is being exercised, it should be resolved by a restrictive approach.
But this was concerned with secondary legislation rather than, in our case, primary legislation, because that's what the Communications Act is. So the executive have already, as it were, passed the first hurdle, haven't they, of saying this is being seen by Parliament and...
Well, no, my lady. The answer is that this case was concerned with the scope of the enabling power in section 9.2b of LASPA. Primary legislation.
It's the 2 sections, isn't it? So
Yes.
that's paragraphs 5 and 9 and 8 of Lord Newberger's judgment.
Yes.
So section 9, which talks about the Lord Chancellor may by order do certain things, and then section 41, which talks about orders, regulations, and directions under this part.
Yes.
So the primary legislation contemplates that the Lord Chancellor can, just as section 5 of the Communications Act contemplates that the Secretary of State may give directions.
Yes.
So it's the same
And
point.
Exactly. The question is, in the end, what is the scope of the enabling power in the primary legislation? You can see that in Lord Newberger's analysis when he comes to paragraph 30.
All these cases are by definition one bit of primary legislation against another.
Exactly. Exactly.
Yeah.
So it's not an answer to say, well, we're concerned with 2 pieces of primary legislation here. All these cases are. The question is, by reference...
Did the power given by one piece of primary legislation, was it wide enough to trump another piece of primary legislation?
And the ordinary approach to the court is that such a power, for obvious reasons, is exceptional, and therefore has to be read restrictively, and the requirement is for clear words. And you can see the construction of 9.2b going on from paragraph 30 on, but I don't place reliance on the particular reasoning on the provisions in that case. But the need for clear words, I submit, is perfectly clear. Another example of a similar approach at tab 19, the next tab, the ingenious case. This was a case in which a senior official at HMRC had given an off-the-record briefing to journalists about the tax affairs of a film finance company and its founder. And the issue was, were those disclosures authorised by statute? And Lord Toulson gave the judgment for all 5 members of the Supreme Court. You can see at paragraph 2 on page 4166, Lord Toulson sets out section 18 of the Act. So again, it's primary legislation, and it said, and he has italicised the relevant bits, there's a prohibition on disclosure of information in subsection 1, and then it said, subsection 1 does not apply to a disclosure which, 1, is made for the purposes of a function of the revenue, customs, and so on. And you can see right then at the bottom of the page, last line, subsection 4C said a reference, this is the italicized bit, to a function of the revenue and customs, a reference to a function of the commissioners or an officer. And then in 6, paragraph 6, Lord Toulson recites that section 51 defined function as meaning any power or duty, including a power or duty that is ancillary to another power or duty. Now, when it came to interpreting those provisions, Lord Toulson, in paragraphs 19 onwards, at page 4170, came to ask in the third line, what then is the proper interpretation of the far broader words of subsection 2A1, disclosure made for the purposes of a function of HMRC? On HMRC's interpretation, it would be hard to conceive of a wider expression by taking 5, 9 and 51 in combination. It's said to include anything which in the view of HMRC is necessary or expedient or incidental or conducive, etc. If that's the right interpretation, it means that a number of the subsequently listed specific exceptions are OTOs, and then he says, a few lines down, secondly and more fundamental.
So sorry, I've lost which paragraph are we in?
Paragraph 19,
Oh, yeah, got it, yes.
below D. Secondly, and more fundamentally, it means that the protection which would otherwise have been provided to the taxpayer by HMRC's duty of confidentiality will have been very significantly eroded by words of the utmost vagueness. Now, remember that the words in that case were disclosure for the purposes of a function of HMRC. And Lord Toulson says those are words of the utmost vagueness. So to construe the words would run counter to the principle of construction known as the principle of legality, reference to Sims. Paragraph 20, Lord Hoffman said that this presumption will apply even to the most general words, but I would say further that the more general the words, the harder it is likely to be to rebut the presumption. A similar principle can be seen in the court's approach to the interpretation of powers delegated to the so-called Henry VIII clause.
Well,
and then
this is obviously an interesting, important case.
Public
It's
law.
further from our case, isn't it, than
it is.
TLP, and I'm not
It is.
thought it
I
has.
accept that. There's then another statutory interpretation case, the final one I want to show you in this line, J and the Welsh Ministers, Authorities, tab 22. The issue here was whether a community treatment order under the Mental Health Act 1983 could lawfully include such stringent conditions that it amounted to a deprivation of liberty, and the Supreme Court said there were no clear words authorising this. If one goes to page 92 of the report, paragraph 23 in the judgment of Baroness Hale, common ground, there's no express power to impose conditions. The Court of Appeal nevertheless held that there was a power by necessary implication. The purpose of the CTO, they said, is the gradual integration of the patient into the community. There must therefore, by necessary implication, be a power to provide for the lesser restrictions, etc. Baroness Hale says in paragraph 24, with the greatest respect to the Court of Appeal, this approach puts the cart before the horse. It takes the assumed purpose of a CTO, the gradual reintegration of the patient into community, and works back from that to imply powers into the MHA which are simply not there.
But this is again dealing with a slightly different
It is.
point, this is the point about whether general words can override fundamental rights.
It is.
Maybe it's all part of an overall
It is.
General point, but it's really that first case you showed.
It is.
That's the public law project case.
What you essentially get is that where delegated legislation purports to interfere with established principles of legal policy, the courts adopt a restrictive approach to the enabling power. That might be inconsistency with primary legislation, it might be inconsistency with fundamental rights. It's perfectly clear from Public Law Project that that approach squarely applies, where the power being claimed is one to alter what would otherwise be the effect.
Yeah.
primary
Okay, well, I think
legislation.
you've made your general point clearly
Yes.
enough.
And the point I wanted, very briefly, taking the hint from paragraph 24, is the point about the cart before the horse. Taking an assumed purpose of a provision and then working backwards from there, because I'm going to come to that in the context
So 24 of this is at 24.
of
Lady
Jay and the
Hale's
Welsh
judgment.
ministers. So, my lord, that's the point. It's summarised quite neatly in Bennion at tab 25, paragraphs 3.7. Well, in fact, you have the point, but there's a summary there of the proposition. So, adopting that approach, the question is: are there clear words authorising Section 8, subsection 4, to be overridden? That's the question in our case. And when one goes back to Section 5 of the Communications Act 2003, which is at tab 4, page 26, we say clearly there aren't. Now, the starting point following Lord Newburgh is to look at how general or specific the issues under contemplation actually were. Now, because he says that whether a general word, you can't reliably infer that Parliament confronted the overriding which is said to be enabled. The more general the words, the less likely to be the case. And it is useful in that context to look at the functions to which Section 5 applies. Now, Section 5, page 26 of tab 4, applies to Ofcom's functions under Part 2 and its functions under the enactments related to the management of the radio spectrum that are not contained in that part. Now, you have the whole of Part 2 in there. It runs from sections 32 to 197 of this Act. I'm obviously not going to take you through it all, but there is a very large number of functions and duties of Ofcom contained in those 166 sections. It includes a whole swathe of statutory duties in relation to networks, services, and the radio spectrum, the setting of general conditions, telephone numbering, universal service obligation. And I can show you some examples if one goes to section 44 on page 42. We have a duty on Ofcom to keep a publicly accessible register. On page 50, section 52, we have a duty of Ofcom to set general conditions as they consider appropriate in relation to customer interests. 53, the process for the approval of codes of practice. One can go on. 56, there's a duty to have a national telephone numbering
You get the general gist.
The-
And it includes
now-
exemptions and licensing.
My learned friend's linguistic argument, he doesn't say there's anything about Section 8 of the Wireless Telegraphy Act 2006 that makes it particularly susceptible to being overridden by a direction under Section 5. He simply says Section 8 is a duty contained in the Wireless Telegraphy Act 2006, which is one of the enactments related to the management of the radio spectrum. 5.1b. Now, if that argument is correct, then all these other duties would also be susceptible to being overridden by a direction under Section 5. And you can see it's not even just the 1949 Act. The definition of the enactments related to the spectrum is at section 405, which is at page 179. The enactments relating to the management of the radio spectrum means, and then there are a further 6 Acts of Parliament set out.
Is that so? I mean, your point, I think, is the one you've just made. If Mr. Beard is right, any of the provisions in any of these statutes and any of the provisions of Part 2 could be overridden.
Yes.
But how does that help you? I'm sure he'd be comfortable with saying that. He can only override them in very limited circumstances, which are the ones set out in subsection 3 and are essentially to do with national security. Most of them, such issues will never arise, but if they do, why not? Why is this a good point for you?
The reason it matters is what Lord Neuberger says about general words and how confident the court can be that the power claimed in the particular case was within the contemplation of Parliament. My Lady Justice Macur made a very salient observation this morning about the risks of construing a statutory provision by reference to the particular facts that arise in a particular case. Now, my learned friend's submissions were all made on the premise that what Section 5 was really all about was its interrelationship with Section 8 of the Wireless Telegraphy Act 2006. But there is no intrinsic or extrinsic indication, whether from Section 5 or from the explanatory notes or elsewhere, that is something that Section 5 was specifically concerned with or that Parliament even thought about.
Well, in the context, you have to be careful taking general observations and applying them to different sorts of legislation. I don't think Lord Neuberger can be taken to have meant that in a case like this, Parliament must have appreciated specifically that Section 8 could be overridden. What Parliament should have appreciated is that national security could trump any provision. They obviously did in principle contemplate that, didn't they? That's what section 2 and 3 achieve.
The question is, can one obtain by clear words from Section 5 that it was intended to be a power that extended to overriding duties in other bits of prime religious?
Yeah, well, then that's your real point.
It is.
Your real point is that it's about overriding duties.
Yes.
Not all of these provisions will provide for duties. Most of them will be only functions.
But that's why I took you to duties, and I could have carried on
Yes, I
for
see.
some time. My own friend's argument has to be that they're all susceptible to being overridden, but in any event, leave that aside. What he needs to show is that there are clear words enabling the overriding of Section 8 of the 2006 Act. There are no words authorising the overriding of any statutory duties in Section 5 of the Communications Act 2003. It says, well, we've seen it many times today, what Ofcom's duty is.
At the time when it was enacted, what's now Section 8 is in fact what was inserted in Section 1AA.
Correct.
Which is Section 166. But it's exactly the same point, isn't it? Because
It is.
that said that if Ofcom satisfied in relation to no undue interference, then it shall grant an exemption.
Yes, and it would have been, I come back to it, I know I'm repeating it, but it would have been very easy to include words making that duty subject to a direction under Section 5. And that was not done. On the contrary, Section 5 says it shall be the duty of Ofcom to carry out those functions. Now, if one interpolates duties for functions there, which is what is the starting point of my own friend's argument, it should be the duty of Ofcom to carry out the duties in accordance with such general or specific directions. That cannot, on any view, regardless of which particular piece of language one is focusing on, that can't sensibly be described as clear words authorising another statutory duty to be overridden.
This is probably over-refined, but do you make anything of it? It's very standard legal English, talk about carrying out a function. Slightly clumsy to say carrying out a duty, you perform a duty. Maybe that point by itself doesn't bear much weight. Is there anything in it?
Well, I mean, I wouldn't, you're right, my lord is absolutely right, but I wouldn't put too much emphasis on perform versus carry out. What I do put emphasis on is the point that in the context of a search for clear words, to say that carry out includes not carry out, in the context of a claimed power to override primary legislation, it's just not possible.
And that, you say, is the point of the appeal. It just cannot bear the negative as well as the positive.
Yes, and it's the reason it's important is all the reasons that are explained in the cases. It matters to hold ministers to what Parliament they can and can't do.
Your point here is that even if you could say in general terms, for example, if you were construing provision in a contract, you could say, well, using the use of the words carry out in that provision must also encompass not carry out in order to make commercial sense. You say, well, that's not here. Well, there have to be clear words which confer a power to effectively to override a statutory duty elsewhere. Yeah. And you just, however you construe it, you can't say they are clear words.
Yes. And I'll be coming to it. There's an example in section 94 of the Telecommunications Act 1984, where Parliament did impose a duty and actually say that you have to obey a direction notwithstanding a duty under any other piece of primary legislation.
Well, it's there in section 5 of the Telecommunications Act 2006. What was section 154 was a subsection which makes it clear that it's always subject to the duties under section 3 to provisions of section 3 to 6.
Your Lordship's ahead of me there, but the reason I picked 94 as an example is that it's actually referred to by Lord Justice Richards as one of the contextual factors influencing him in recall.
I think in a way it's a slightly stronger point, isn't it? Because it actually talks about one duty trumping another, in priority to another, whereas I think the provision my Lord has in mind, which I now can't find.
It's 154 in the Communications Act, but
it's
where it appears.
It's section. That's right. It's section. No, I'm wrong. It's exactly. It's essentially the same thing.
Where's the one that?
Please.
Yes. So I'm going to end up taking this out of order now. But
sorry,
since I've
section 94.
So text tab 12 is the one that Lord Justice Richards was referring to in the recall Court of Appeal.
Which
Section 94, subsection 3. A person to whom this section applies shall give effect to any direction given to him by the Secretary of State on this section, notwithstanding any other duty imposed on him by or under, and then there's reference to a series of other statutory duties. So when Parliament wants to give a direction power that is capable of overriding other bits of primary legislation, it says so. But the point actually goes further, because I do ask the court to note the source of the amendments to this power that you can see in the notes over the page. It's the Communications Act 2003. This very provision was amended by the Communications Act 2003. So if you go to tab 4, page 187, paragraph 70 of Schedule 17, 2003 Act.
Sorry, page 187.
Page 187, tab 4.
Yeah.
The draftsman of the 2003 Act was actually concerned with section 94 and made various amendments to it. So not only do we say that the draftsman has to be taken to be aware of provisions
He's actually
of that nature, he or she was actually looking at when drafting the 2003 Act. And to say against that background, given section 154, given the failure to qualify section 166, given the use of the words, the very clear words, carry out, in section 5, subsection 2, given the decision to amend section 94 of the 84 Act.
So what happened to section 94? It just wasn't reenacted in the 2006 Act.
I suspect Mr. Beard will know more about this than I do, because I think it relates to the whole saga of dripper and bulk collection warrants, and I don't have an answer for you, but I know it assumes...
Well, as a matter, you may not know why, but that must be. There is no equivalent to this in the 1990s.
It's in the Investigatory Powers Act that was enacted. That's what's taken over the Telecommunications Act. So Mr. Segan is right that this power was the subject of consideration in cases concerned with the gathering of bulk data. And
So where is it in REPA? Is it? I'm sorry.
it's IPA, it's not RIPA.
Oh, it's IPA, not
It's
REPA.
IPA.
Okay.
I'm sorry, I don't have the reference. I can get it
Don't
for
worry,
you, but
don't worry.
that's what's happened to it. It was this power that was used and argued about for bulk data collection, and that power was then withdrawn and is dealt with in the investigatory.
When you say it's dealt with, I mean that powers in equivalent terms.
I believe that's right. I'd have to check the precise wording of that. I'm sorry, I don't have.
Well, I'm sure it's not central, or we would have had submissions about it. But I think just so that we can tell the story in our judgment, it would be quite useful
we'll track
to
it.
have ideally an agreed note about
Just
this.
short note
Yeah.
saying and setting out the terms of if it's different from 94, what it now is. Be useful.
We'll do that.
Thank you. Yeah, and ideally in agreed terms. So
My lords, my lady, that was the first of my 5 points that I did.
Yep.
In the skeleton, clear words, there aren't any here. Point 2 is the EE limited case. And I accept, of course, it's a different provision, but the point I rely on it is instead the underlying principle applied by Justice Patton of looking for whether there were clear words in Section 5, in that case, of the Wireless Telegraphy Act 2006, that authorised Ofcom's other statutory duties to be overridden. And we have E limited at tab 21.
But just so I understand it, you're really just saying this is merely illustrative of the principle of your first point in play in this particular field.
That's right.
So it's not of great importance to us. It's not in any way binding authority.
No, I'm
it's just
not.
illustrative application of principle.
Yes, I'm not.
Well, we don't spend much time on it. That's all
Okay,
it is.
let me take it very briefly. So this was, in effect, the obverse of the present case because the Secretary of State had made a direction under Section 5 of the Wireless Telegraphy Act 2006, and one of the questions was whether that direction could override duties contained in the Communications Act 2003. Let me just pull it up very quickly. Paragraph 23, page 1878. Second line. There is no doubt that the Secretary of State may give Ofcom directions in respect to the charging of licence fees, but one of the primary issues on this appeal is whether and to what extent the giving of such a direction is capable of displacing duties imposed on Ofcom by sections 3 and 4 of the Communications Act 2003, or those imposed under Article 8 of the Framework Directive. So that was what they described as one of the principal issue, what had happened was that the Ofcom, having received a direction, you can see this from paragraphs 30 and 31, to calculate licence fees by reference to their full market value, had considered in effect that exhausted their other, or took precedence over their other statutory duties. You can see at the end of 31, what is in issue is Ofcom's admitted failure to have regard to what I shall call the Article 8 considerations in setting the amount of the fees. And the High Court dealt with the case in a way that you can see at paragraph 37. At paragraph 93 of the quotation, the High Court said, thus as a matter of domestic law, once the Secretary of State has given a direction under Section 5, Ofcom's duties under provisions like Section 4 of the 2003 Act and Section 3 of the 2006 Act are replaced by its duty to comply with it. So that's very close to the argument being advanced by the Secretary of State in this appeal. And then the virus issue is dealt with at paragraphs 49 onwards, page 1887. And you can see what the submission was in paragraph 51. EE submitted that there's nothing in either the 2006 Act or CRF which permits the Member State to remove a regulatory function, etc. In the United Kingdom, the function of setting licence fees has been delegated to Ofcom by primary legislation, and absent clear words, that position cannot be changed by subordinated legislation in the form of the 2010 direction. By the same token, the direction cannot have been effective to remove the duty. 52, it said the question of virus turns on Section 5 of the 2006 Act. Just in relation to a point that my learned friend made, next to letter G, you can see that the court found that it wasn't necessary to resort to EU law. So it's resolved as a question of domestic statutory interpretation. And at 54, Lord Justice Patten says, the question therefore arises whether Section 5 authorises the Secretary of State to direct Ofcom in exercising its Section 12 powers to ignore the duties imposed on it by Section 4.2 and Section 3.5. In my view, it does not. Parliament has imposed those duties on Ofcom to be performed in carrying out its radio spectrum functions. It did not obviously contemplate, or in my view, authorise the performance of the Article 8 duty by someone who is not the regulator, etc. And then again, the principle that I'm extracting from this last 5 lines of that paragraph, in the absence of clear words, the Section 4.2 duty is to be treated as non-delegable, and there is nothing in Section 5 of WTA.
Well, there's two things at that point. It's also the point about not carrying out, which, although it's different from this point, it's essentially the same point, isn't it? Because what's being said there is, well, what the Secretary of State is purporting to do is to take the powers to himself or herself. So Ofcom's not carrying them out.
Yes.
So it's not a direction in relation to the carrying out of powers, because on this hypothesis, Ofcom's not carrying them out.
That's right, yes.
So in that sense, although it's a different piece of legislation, the principle is not similar.
It is. And he ends that paragraph by saying the language of Section 5 is entirely neutral. So the search that the Court of Appeal embarks on was exactly the search which I say one has to undertake here. You have to look at the language of the power set to confer the power to override another duty. Ask, are there clear words? If they're entirely neutral, that is not good enough. There needs to be explicit authorisation. And that is the effect of all of the authorities I've shown. Now, my learned friend says, well, EE is different because of different statutes, etc. I make absolutely clear that I'm not relying on it as in any way deciding the case, but the underlying principle is absolutely consistent with the case that we advance, and the way in which the court dealt with the issue in paragraph 54 is absolutely consistent with and supportive of our case.
May I just ask, Mr. Sagan, in reference to the Framework Directive, they're referring to Article 8, but the directive that we've been asked to look at, the part of the directive we've been asked to look at, is Article 7. which provides for the possibility that the scheme of deregulation should be subject to national security issues. Does that make a difference?
Well, on the EU issue, I should be clear that I don't dispute what Mr. Beard said, that there are recitals indicating, and there are recitals like this in all sorts of bits of EU legislation, that national security is a matter in principle for the member states. So I'm not suggesting, and it's no part of my case, that the EU law framework mandated any particular outcome in terms of the abolition of individual licensing. The reason it's relevant is that lots of my learned friends' submissions are based on the premise that it is unthinkable or bizarre or unexpected that Parliament should have dealt with a particular issue in the 2003 Act, not by individual licensing, but by reference to general exemptions with conditions attached. But in my submission, you can't get to that point when you see that the framework that was being implemented was a framework that was concerned with the abolition of individual licensing regimes. So it's very difficult in that context to say that Parliament's judgment on a particular issue where it's decided to get rid of individual licensing is on its face unthinkable or irrational or absurd or leaves a lacuna or whatever the expression may be. So I'm not saying that the CRF mandates, but it does make it very difficult for it to be said that the abolition of individual licensing in any particular context is unexpected.
Well, can you say that? And you can say that it would be unexpected in cases where there's a clear threat to national security. I mean, that's not unexpected, is it? You can suggest that.
Well, it depends how one looks at the framework, because on one view, it's a perfectly coherent framework that Parliament sets up for dealing with the issue. There's a duty to exempt, but there's a power to direct the conditions on which the exemption takes place. I'm going to come to this in the context of the lacuna argument. There is then an ability under Section 132 to make directions in individual cases. And then there is always the reserve power of the Secretary of State to alter by delegated legislation, as occurred actually in 2011, the terms on which the duty to exempt is actually operated. So you'll see when Section 8 was amended in 2011, with effect from 2011 to give effect to the Better Regulation Directive, that was by a piece of delegated legislation. So when one puts all of that together, it is not on the face of it, I'll come into this in the context of lacuna, but it's not a scheme which on the face of it is an irrational scheme for the protection of public interest.
But so far as my lady's concerned, if I got this right, you are not saying, and you could not say, in the light of the directive, that there's anything wrong in the Secretary of State exercising his powers, or her powers, in order to protect national security.
No.
But the question is how she goes about it.
What are those powers? Yeah.
But it goes back to the judge's point of paragraph 81, which we debated with this morning with Mr. Beard. That the second part of the direction is, if you took it on its own, is unobjectionable. You need to tinker with some of the wording.
Yes.
But it effectively saying, well, if you grant exemptions, it should be on the following conditions, in A and B.
Yeah. And if you do that and people don't follow the conditions, then they're not within the scope of the exemption. And they're operating without a license and committing a criminal offence in just the same way as they would be if they had not applied for a license under an individual licensing.
Well, we're slipping into the lacuna. Was that going to be your next? Your time also is not that extensive, and you're going to be economical. Is the lacuna point your next?
It was not, but it was raised by the question.
No, of course, I wasn't getting it. I was wondering whether it made sense to come to it now, but not if it's very
I should
order.
put it very briefly. I think I can take the next point very quickly, because you've indicated that you're not going to be assisted by lengthy submission on the recall case. The third of my 5 points in the skeleton is recall court of appeal. Now, I quoted the relevant passages in my skeleton argument.
Well, you're entitled to say that an extremely experienced public law justice was concerned about this point, but it was all overturned.
It was all overturned.
It wasn't fully argued, and we have heard full argument.
The last bit I wouldn't necessarily agree with, actually,
all right,
my lord, because it was.
You were in the case.
It was a core issue. You will see when you come to look at the judgment.
Yeah.
Ground 1B was actually expressly concerned with domestic law. Now, the way in which Lord Justice Richards has to resolve the issue meant that he didn't have to.
The key points are it was obiter, and also he didn't even express a firm opinion obiter. He expressed a tentative opinion obiter.
That is right. That is true. But what he does say, and of course the other members of the court agreed with him, and it feeds into the clear words, is that Section 5 cannot readily be interpreted as conferring the power that's claimed in this case. And in my submission, that's the important thing. And that there's no doubt is why he was using that language. If a power cannot readily be interpreted as conferring the power that override primary legislation, then it shouldn't.
Anyway, there we are. We see what your points are.
That's recall.
Yep.
The fourth of my 5 points in the skeleton is the contrast with Section 94 of the 84 Act, which we've already done in the course of questioning, and you have the point about it actually having been amended by the 2003 Act. Then the fifth point that I rely on is the conflict resolution provisions, which I've again already taken you to in Section 3.5 of the Wireless Telegraphy Act 2006 and its predecessor in Section 154 of the Communications Act 2003. And in my submission, the fact that Parliament did provide for certain duties to be capable of being overridden by a direction under Section 5 tells you all you need to know about whether Section 8 was capable, because Parliament didn't provide that. Now that ends the second chunk of my submissions. The third chunk is to pick up any remaining points in relation to my own defence grounds of appeal, and that will include the lacuna point. And here I come to it. Essentially, my own friend has 5 grounds. The first is the alleged lack of a good reason why Parliament would have set up this scheme. And my own friend says there is a lacuna here on the face of it. Now, the first point is I don't accept that that is the right way to approach the problem, or that it's the right question. As I've shown you, Section 5 is actually concerned on its face with whole chunks of the Communications Act 2003 and with the whole of the rest of the Wireless Telegraphy Act 2008. There's no indication it was actually concerned with the preservation of individual licensing regimes at all. And of course, it's not, as my own friend accepts, concerned exclusively with national security at all. There are other issues. So one can't work backwards from a perceived lacuna on the fact of a particular claimed application of the power and determine the proper construction of the section. That brings me to the second answer, which is the cart before the horse submission. I showed you Jay and the Welsh ministers at tab 22, and we say that is exactly what the Secretary of State's argument is doing. The Secretary of State asserts that Section 5 was enacted with the purpose of enabling the provision of individual licensing regimes and enabling Section 8 to be overridden, but that just begs the question. You can't assert that and then work backwards. And to an extent, that accepting that, then the submission was moderated in paragraph 20 of the supplemental skeleton, where it said Parliament should be taken to intend that the statute would enable necessary and proportionate measures to be taken to protect critical public interests. Now, expressed at that level of generality, it would be hard to disagree, but the question, of course, is which measures, which powers, and did they include being able to override the statute, and for all the reasons I've given, plainly they didn't. Thirdly, we say there is no lacuna anyway. And to an extent, I've addressed this in my answer to my Lady Justice Macur's question. The scheme set up under the Communications Act 2003 and indeed the Wires Telegraphy Act 2006 protects the ability of the Secretary of State to protect national security, but does so in a manner that's consistent with the overall thrust of the Authorisation Directive to abolish individual licensing regime. As I showed you earlier, the directive was concerned with using the least onerous authorisation possible. And we've seen that the way that that was dealt with is there's a duty to exempt, but of course the conditions that can be attached to such an exemption are a matter for Ofcom and can be a matter for direction from the Secretary of State.
But that's said by Mr. Beard simply to be licensing by another means, because the only way to make it effective would have to be a condition of the exemption that you essentially put in a return to Ofcom by which it must be satisfied. There was some suggestion the Secretary of State must be satisfied, but I wouldn't have thought that was right. That effectively you can see through the gateway to the end caller. And as it were, show how you're doing that. I suppose the difference from licensing is, well, there is, I can see, a theoretical difference from licensing, because there doesn't have to be any authority then to go on. It, as it were, puts the onus on Ofcom to say, well, we don't think that's good enough, and we're going to prosecute. That's how it would work, would it?
It could, but I think ultimately this issue comes to what one regards as a lacuna, because the term has been used in a way that equates in essence with what I think the word that my learned friend used, words my learned friend used, were optimal and suboptimal. If there is a scheme that the Home Secretary, on the facts of this case, regards as suboptimal, then there's a lacuna. Now, in my submission, that's not nearly the hurdle that one would have to surmount to get to the point of saying that there is a lacuna on the facts of this particular application of Section 5 that justifies one then working backwards and adopting a strange reading of Section 5, which will, of course, if adopted, apply ex hypothesi to all possible subsequent applications of the patent. That is the wrong way to go about the case. And my learned friend's approach to essentially presenting the court with a problem and then saying one has to work backwards from there, a practical problem, is not the right approach. If the Secretary of State has concluded that the scheme set up by Parliament leaves her with insufficient powers to act to protect national security in this context, then the solution is to fix the powers.
Well, I see that up to a point, but let's just assume, which you, of course, wouldn't accept, that the language is ambiguous and we have to choose between two readings. A powerful consideration would be, if it were the case, that the Secretary of State can't have intended, sorry, not worry about the Secretary of State, Parliament can't have intended the Secretary of State to be deprived of a power by some form of direction to preserve national security interests.
Yes.
And if you can't point to any power to do that, or any way in which that could be done, that might be a strong incentive on us to adopt Mr. Beard's reading, assuming we thought it was at least possible.
Yes, I see that. Now, let me address...
So that's what I mean by lacuna,
Yeah.
whatever anyone else may mean by it.
Understood. I hope I'm forgiven for answering that, at least to start with, by backing up and assessing whether the starting point is right, because your Lordship put it to me on the basis, what if the provision is ambiguous? If the provision is ambiguous, then in my submission, on all the authorities I've shown you, that is the end of the analysis, because what you're looking for is clear words. So that's,
all right.
that's
You made that point. I'm not
Yes.
totally convinced it's a complete answer, but still.
But that's what I say to start with. Then one has to move to asking, well, what is it about the legal framework that is inherently unsatisfactory here to such a high degree that it justifies straining the interpretation of Section 5? And it is said simply that the Secretary of State would prefer a situation where people have to notify individually to Ofcom rather than an exemption on condition.
But you said a moment ago about exemption on conditions, in answer to the point that was made, well, that it would follow from that people in the position your client would choose just never to notify Ofcom and just to carry on. That, of course, would be illegal. Ofcom might not find out, but equally, if somebody were operating an unlicensed business, Ofcom might not find out about that either.
Yes.
So there's always a potential gap in the regime.
And it comes to the same
people
thing.
who operate unlawfully.
And of course, the question has been put to me, well, why does it matter? The answer is, of course, the whole scheme. That's why I showed you the directive. The whole scheme was concerned with setting up regimes under which there would be general...
We've got. I speak for myself. I've got that point, but perhaps I'm really just being very laborious in getting to a point that doesn't cause you any difficulties. But I think it is inherent in your answer to what I call the lacuna point that there isn't a lacuna because the Secretary of State can impose national security conditions.
Yes.
Secretary of State can direct Ofcom to impose national security conditions in its exemption regulations.
Yes, that's true.
That is important for you to say that, at any rate as a fallback position.
Yes.
Because otherwise we will be straining to say, but then I think your point is yes, but we don't have to work out to the nth degree exactly what those conditions would be or whether they will be quite as good.
Yes.
We're just looking at Parliament's intention.
Yes.
And Parliament would have assumed that the Secretary of State could do what could use that tool adequately.
Yes.
If it turns out you can't, there's something absolutely crucial in doing it the other way around, well, then you better change the primary legislation.
Yeah. And there is also, remember in all of this, you're looking at the scheme as a whole. There is the Section 132 power, which has to be brought into the equation. If one is asking, well, is there a lacuna? There is a power to intervene in individual cases,
Yes, but
even if you've already attached conditions.
Okay, I agree that's part of the overall picture, but that isn't quite the same kind of power.
And of course, as Mr. Justice Morris noted at paragraph 84, there is the further point that if there really is perceived to be an insoluble problem, then one course of action would be simply to amend Section 8 so as to introduce...
Right. I mean, primary legislation is always a nuisance for a busy government.
Understood. But remember, that's why I made the point, actually, that the last time it was amended to introduce the expanded list, that was by delegated legislation, because Section 8 implements Article 5 of the Authorisation Directive.
So are you saying as long as they do it before December the 31st, they could amend the primary legislation in order to Well, let's not go there. One way or another, they can do it, is your point.
Yes.
Yes, okay.
Your Lordship was about to trigger a very long, boring answer about the Brexit legislation, so I think it's probably wise we don't go there. But that's a fallback at the end of the day, as is primary legislation, but your Lordship's point is amply taken. In the end, one does have to remember what my learned friend is really asking you to do here. I don't want to be too inflammatory about it. I obviously recognise the extreme importance of national security, but it would be a significant step to take a different approach, or a strained approach, to the interpretation of a statutory provision because of a national security context. That is not something for which my learned friend has brought any authority before you. And it's something which in other contexts might be a less attractive and more dangerous proposition for a court to accept. So, obviously I'm not going to get into Liversidge and Anderson and all that sort of thing, but it is, in the end, what my learned friend is asking you to do is to strain the reading of Section 5 because of a national security issue. And that is not something which historically the courts have done, and it's contrary to the clear words approach. Okay,
so we got to Lacuna. Well, was it? You said you had 5 grounds of appeal.
well,
We're still on the first. Time is short, so
yes,
there's only had to be a reply.
yes.
This one, as you can tell, is of interest to us. But cut your coat according to your cloth with the rest.
That I shall. The second one was the expressio unius argument, and it wasn't developed as such from my learned friend. But the point in the end is that because there are various carve-outs in Section 5, it can be taken that anything not carved out is conferred by way of power. And that's just not a correct chain of reasoning. The starting point of the argument is that in the absence of expressly, Section 5 would confer an unlimited power to override statutory duties, but that assumes the issue that arises in the appeal. So in my submission, expressio unius really is not going to help you here. I've cited in the skeleton argument the Swedish club and the EN Serbia case, saying that it's an often perilous principle and not a particularly strong rule. We say the judge was absolutely right to hold that if the point had any force at all, it certainly wasn't sufficient to displace the conclusion flowing from all the other points in the case, and the points developed in these skeletons. The third ground of appeal was a submission that there is actually no need for clear words, that the line of cases I've shown you is inapplicable because this is a case about 2 duties. I hope we've dealt with that in the exchanges in relation to the public law project case. It's not right. All these cases are concerned with the clash between 2 pieces of primary legislation, and the question is always, does piece of primary legislation A enable piece of primary legislation B to be overridden? Then the Secretary of State's 4th point is to say that there actually are clear words. Well, I think I've dealt with that. I should just address the point that my learned friend made about Section 4, subsection 2, and the similar language. I would make 3 points about that. First of all, one needs to be careful because Section 4, subsection 2 is not concerned with a direction power at all. So it is a materially different situation which doesn't bring into play any of the concerns about delegated legislation overriding primary legislation. Secondly, it is different because there is a conflict resolution provision in Section 3, subsection 6. And thirdly, if it is right that the duties under Section 4 could automatically override other duties in the statute, then that must be because, as was observed in argument, it is a question of EU law, rather than because it's a question of domestic statutory interpretation. There's nothing that leads one to that conclusion as a matter of domestic statutory interpretation. So section 4.2 doesn't help you. And then fifthly, my learned friend relies on the EE limited case, not, he says, helping you. Well, I've addressed that, set out why we say, I hope in an appropriately moderated submission, that assists my submission of principle. And the way that the Court of Appeal approached the issue in that case is absolutely consistent with the way we approach the issue in this case. So for all of those reasons, when one stands back and asks, does Section 5 clearly confer a power to override Section 8? The answer, we say, is no, and the High Court was absolutely right so to hold. Unless I can assist further, those are my submissions.
Yes, thank you. Mr. Beard.
Great. Start with the EU point that Mr. Segan started with. With respect, it's not even just neutral to Mr. Segan, it is against him. The scheme that was adopted in relation to 1AA was a scheme that derived its momentum from the Common Regulatory Framework, which was to generally give more authorisations rather than licensing regimes. No doubt about that. I hope I was clear about that in opening. However, as I was also clear, and the Court has recognised implicitly through its interventions, that scheme was explicitly subject to public security considerations and indeed national security considerations. So what Mr. Segan is saying is that by the implementation scheme that was adopted in the Communications Act, the UK has effectively gold-plated the general authorisation mechanism such that there are no ways of imposing a licensing regime for national security reasons. And there is simply no reason why, when implementing a scheme which admits of member states doing that, the Parliament would have intended that to be the case. That just doesn't make any sense. So actually, the position when you look at European law and say, well, you're implementing European law here, the natural supposition is you are going to preserve those protections in relation to particular national interests that European law recognises. And that goes to reinforce why it is that Section 5.2 and 5.3 are so important, because they are the only part of that whole implementation scheme that deals with national security. I leave aside the urgency matters. That's the bit that preserves that interest. So it is just the wrong way round to suggest that the EU law helps him, and it is not even the case that it is neutral. It is against him. There is no reason, when we ask ourselves what Parliament intended, that it intended to remove that option. And I say remove that option because, of course, prior to the Communications Act, that scheme for requiring licensing was open to the Secretary of State and was maintained up until the point when this consultation was undertaken. So EU law is strongly against him. Then when we move on to the case law he refers to, the Henry VIII Powers case law and the Public Law Project, he's right in one sense to say all of these cases involve two sets of primary powers. Of course they do, in the sense that secondary legislation can only ever be made under primary legislation. The clue is in the title, it being secondary. That does not tell you whether or not the scheme that you're talking about involving relevant legislation is such that one says that the intent of Parliament is has to be set out in particularly clear words in circumstances where you're dealing with, in this case, a key public interest, and we do rest on that, one that was expressly confined and delimited, we do rest on that, in the single provision in relation to this overall scheme. that really deals with national security. And I recognise there are provisions in 132 and so on that deal with matters after people have entitlements, but the prior protection of national security is only in 5.2 and 5.3. And yes, that does apply to all functions and duties. Yes, it does. And that's entirely understandable and proper. Why wouldn't Parliament intend that protection to be there? As to the clear words, every one of the cases that Mr. Segan refers to is concerned with overriding a substantive fundamental right. Public law projects about access to justice, Ingenious is about confidentiality, Jay and Welsh Ministers is about liberty. We're not dealing with those issues here. You can't carry that reasoning across. And if you look at public law projects specifically, what it was really to do with was whether or not a power to vary and limit services could be read as curtailing the limits of the people that could get those services. And Lord Neuberger said, no, that's not an issue to do with clear wording. That's just statutory interpretation. Indeed, it's why Lord Justice Richards said, in passing, when he expressed his concerns, I don't think this is a JCWI type issue, because it's not. It isn't about clear words, and that starting point is the wrong one. You need to look at the intention of Parliament. That is all that matters here. And when you're not dealing with fundamental rights, there is no reason why one should look at this and say we need particularly clear words. The second thing to emphasise in this context, of course, you're dealing with a single legislative scheme. As my Lord Justice Flaux emphasised, it was Section 166 of the Communications Act itself that brought in 1AA. It wasn't some other piece of legislation. You can understand why courts properly are concerned about the executive taking one legislative scheme and using it to undercut another. The context here is different. The scheme was built at the same time. And what is being said is that a gap was left in the scheme as compared with what existed before. And that's before I get on to the lacuna. And so we say it is sufficiently clear here. And actually, if you go to Lord Neuberger's judgment, in paragraph 30, he says that if the context was sufficiently strong and clear, he might reach a different conclusion even in relation to this sort of statutory interpretation exercise. And here we do have a strong and clear context, which is the protection of a fundamental interest. Mr. Segan adverted to issues of Liversidge and Anderson, and national security issues not being ones that should give this court a basis for reading the 5.2 and 5.3 provisions clearly as we suggest. Those are aspersions being cast on what is a fundamental interest to all of us. And that fundamental interest is not only recognised in domestic law, but in European law, and there is no reason to be suggesting that a reading of this statute should somehow be constrained or require particularly clear words to protect a very clear public interest. Then when we come to, I should say, just picking up on the Jay and Welsh case, there was a suggestion in relation to that, that what one shouldn't do is assume a purpose and work backwards. I'm not assuming a purpose here. The purpose is absolutely clear on the face of the statute, that national security is there to be protected. What is being said is that as part of this package, a duty as part of one of the functions was introduced, and essentially you should read the statute as Parliament intending that suboptimal protection of national security in relation to those matters is acceptable, and that's not right. That takes me briefly onto the lacuna point. I don't want to get into precisely what lacuna means, but you have the submission that actually this reading is creating a lacuna as compared with what went before without good reason. It isn't a matter of preference on the part of the Secretary of State. It is a matter of concern for all of us that the Secretary of State is in the best position to protect. And that is why you have the mechanism of the Secretary of State feeding in, through this piece of legislation, directions. You can't have a situation where every national security issue is adumbrated. Obviously not. This is the mechanism by which national security is taken account of. Quickly, in relation to the other provisions that were referred to, it is worth noting that the reference to Wireless Telegraphy Act 2006 Section 3(5), which is this provision that Mr. Segan places weight on, that says where it appears to Ofcom that a duty under this section conflicts with one or more duties under sections 3 to 6, priority must be given to their duties under those sections. And he says, well, if Parliament really cared, it would have built that sort of wording into 5.3. It didn't need to. 5.3 and 5.4 make very clear the priority to be given to national security. And in fact, this provision is talking about general duties under 3, 4, 5 and 6 of the Communications Act, and spelling out that any of those effectively must be given priority to the other duties in the Wireless Telegraphy Act Section 3. But that doesn't assist. In relation to the language that I pointed the court to in relation to Section 4.2, with respect to Mr. Segan, that's the language in relation to community requirements, carrying out in accordance with, he doesn't have any answer to that point. There is no explanation of why it is that you would read carrying out in accordance with in 4.2 as including not carrying out in the language that's put forward, but you wouldn't do the same if that is your inclination as to how to read carrying out in relation to 5.2. And as to the Telecoms Act 94, it was a separate act, separate scheme, but did give rise to a potentially intrusive power, and it was for that reason, no doubt, that the draftsman spelled matters out as they did. Within the context of the Communications Act, as Mr. Segan says, it was amended there. And the idea that whilst ensuring that national security issues are protected in relation to that particular mechanism, the draftsman weren't protecting national security issues fully in relation to other aspects of the Communications Act is something that is not a sustainable proposition. Dealing very briefly with EE, perhaps the easiest way, I'm grateful to Mr. Armitage for this, to describe the difference between EE and the present case. The analogy in the EE case, would be if the Secretary of State here had sought to tell Ofcom not to introduce exempting regulations because it considered that the 8.5 criteria weren't met. That's really what the equivalent of the EE case in this situation. In other words, the Secretary of State turning around and saying, actually, there wasn't undue interference. There was undue interference here, and therefore those conditions aren't satisfied, because that would be repatriating the powers that are given to Ofcom, which fall within Ofcom's competence, that are part of the European scheme that's been enacted, back to the Secretary of State. That is not what's going on with 5.3. It's not a matter of repatriation. There's no dispute, but it is the Secretary of State that has to deal with these matters. One other point it is worth raising, just slightly out of turn, in relation to that case law in relation to the Henry VIII powers cases, is that all of them talk about the concern that arises when the power that is at issue is broadly drawn. You'll recall that Mr. Segan emphasised those passages that says the more broad the secondary legislative power, the more likely it is that any subordinate legislation made under it that cuts across primary legislation will be ultra vires. Of course, here, you don't have that sort of broad power. Parliament has gone out of its way to confine the power to precisely those key issues and competencies that lie with the Secretary of State, and as we've seen, not only limits it in terms of dealing essentially with the operation of functions as they come into operation, or duties as they're discharged at the start. It also, it specifically limits it in relation to both the subject matter, but also the fact that you can't suspend an entitlement using those powers as well. So there's a real limitation both on the subject matter scope and on the type of intervention scope. So this is a paradigm case where it is not general words that are being used. And it is yet another reason why that case law is not of assistance here, and it is just the wrong starting point. The only question is, what did Parliament intend? The idea that Parliament here intended a suboptimal enforcement of national security is simply not a tenable reading. And if the outcome of your lordships and your ladyship's analysis is that, in fact, one can reach the same level of protection so that you can avoid a lacuna, we say we do not accept that that is the case. But if you could avoid a lacuna, we say, first of all, that becomes a de facto licensing regime. No reason why Parliament would say that that was the appropriate course. But in any event, as I say, it may go to questions of relief in these circumstances. Unless I can assist the court further, those are my submissions in reply.
No, thank you very much indeed. The note which you're going to try to agree, obviously the sooner we could get that, the better. Don't intend to impose an absurd deadline, but is it realistic to think we could get something, say, by close of business on Monday?
Yes, I think that. Yes, yeah, that's absolutely fine. Good.
Well, thank you, and thank those behind you and those behind you virtually for the work that's been done on this case and your very helpful submissions. We will, of course, reserve our decision, and judgment will be handed down using the usual procedures, or the usual procedures at least as modified by COVID. Not in fact realistically modified. You will get a draft of the judgment, and we will ask for your submissions on consequential orders and so forth. I'll spell all that out. Thank you very much.